may I request the speakers to please come and join us on the dais? Hi. Hi, delegates who are just coming in, there's space out in the front as well. Maybe just run and get it.
Sorry for this request.
Not at all. We have Mr. Pillai.
This chair looks very. Can you push your chair?
I hope everyone's seated. We'll begin very shortly.
Yeah, that's what happened to me also. Shall I push it down?
No, I want to should I
Okay, like that?
Thanks. Should I push it from the
It has the foot things underneath. Thank you.
A very good afternoon, everyone. I welcome you back to the plenary hall again for session 2B after what has proved to be a very interesting conversation on party autonomy. We now move to a topic that is very close to my heart. We are talking about increasing diversity and access in arbitration and the role of the stakeholders. This session is powered by the Indian Arbitration Forum, which is the first of its kind arbitration bar in India. In fact, the forum also held an event yesterday on the Code of Conduct for Arbitrators, where Justice Roy had a few remarks to make. I would request you to look it up and definitely let yourselves know what the IAF is all about. So coming to what we are here to discuss today, for an aspiring arbitration lawyer and also arbitrators, increasing diversity in all its forms is about breaking down barriers to entry that exist so that everyone can operate within a meritocratic system. In this session, our esteemed panel would be discussing different perspectives relating to diversity from both arbitrators and arbitration counsel and its effect on the quality of the decision-making process. As a housekeeping rule, I again reiterate, we would like to keep the questions reserved for the end, but if you do have something in the middle, please do not hesitate to pass across chits to me. I'll be standing right here, and we will pass it on to the panel. It is my absolute pleasure to introduce you to the chair of this session, Honorable Ms. Justice Indu Malhotra, who's a former judge of the Honorable Supreme Court of India. Justice Malhotra enrolled as an advocate in January 1983 with the Bar Council of Delhi and was the second woman to be designated as a senior advocate by the Supreme Court in 2007 after 30 years of practice. We all know Justice Malhotra as she specialized in the law of arbitration and appeared as counsel in various domestic and international commercial arbitrations, both in India and abroad. She was also appointed as a member of the high-level committee constituted by the Ministry of Law and Justice, Government of India in 2017, to review the working of arbitration institutions in India and to make recommendations for institutionalization of arbitration and suggest legislative amendments to the Arbitration and Conciliation Act. I think, like me, all of us in this room know that she has famously authored the third edition of the Commentary on the Law and Practice of Arbitration and Conciliation. She was elevated directly from the bar to the Supreme Court of India in 2018 and retired on 13th of March 2021. We welcome you, Justice Malhotra. Thank you so much for gracing our dais today. A huge
Thank
round
you.
of applause.
Thank you.
We are also joined by a distinguished panel of speakers, and I start with Mr. Rajesh Pillai, who's a King's Counsel. Mr. Pillai deals with high-value and complex commercial disputes and has had significant domestic and international experience. He has appeared in courts and arbitrations in a variety of jurisdictions over the last 20 years and is regularly instructed in important claims on behalf of corporate clients, high-net-worth individuals, and states. Mr. Pillai's particular expertise includes contractual matters, banking and financial services, financial regulation, and the obligations of directors and trustees, joint venture and related shareholder claims, commercial fraud, commercial real estate and asset management, art and cultural property, negligence, and insolvency. He has led teams in heavy trials, injunction proceedings, and appeals over a variety of sectors. He is often called upon for strategic input in cases involving cross-border enforcement and multi-jurisdictional elements, being noted in the legal directories as someone who understands complexities of unwieldy disputes in a three-dimensional way. We welcome you, Mr. Pillai. Thank you so much for joining us here today. Huge round of applause, please. It is my honor to now introduce Ms. Pallavi Shroff, who's the managing partner at Shardul, Amarchand, Mangaldas and Company. With over 39 years of extensive and highly regarded expertise, Ms. Shroff frequently advises and counsels clients on some of the largest and most challenging litigation and arbitration matters. She specializes in energy, infrastructure, natural resources, mergers and acquisitions, legislative and policy-related matters. She appears regularly in the Supreme Court and the High Courts of India and in arbitrations, mediations, and international legal disputes. She's an alternate member India at the ICC Commercial Court of Arbitration and is also a member of the CII Arbitration Law Committee. She's the managing partner at Shardul, Amarchand, Mangaldas and heads the dispute resolution practice at the firm. She's also the chief mentor for the competition law practice. We welcome you, Ms. Shroff. Thank you so much for gracing the dais today. Last but certainly in no manner the least, I would like to introduce Mr. Vyapak Desai, who's a partner with Nishith Desai Associates in Bombay. Mr. Desai heads the International Dispute Resolution and Investigation Practice at the multi-skilled research and strategy-driven international law firm Nishith Desai Associates. He's a senior attorney with the firm. He specializes in bringing in highest level of analytical and innovative input in cross-border, complex, contentious matters, corporate regulatory investigations, while also leading the corporate and securities practice in the past at the firm. Mr. Desai is known for his innovative, pragmatic, and solution-oriented approach. I now hand over the reins of the dais to our distinguished chairperson, Ms. Malhotra, to take over the floor.
I'm honored to be invited by the Indian Arbitration Forum to preside on this session where we intend to discuss on diversity issues in the arbitral panel for disputes in various kinds of international commercial arbitrations. It has the legitimacy of international commercial arbitrations, investment treaty arbitrations, has come under a serious apprehension, and there is a legitimacy deficit which has been expressed by persons in the developing countries on the ground that the constitution of these panels is by Westerners who are not at all familiar with the peculiar situations which prevail in developing countries. It is felt that the awards are loaded. Even if there is a nominee from the developing country, it's normally a 2:1 award. And these issues have really gained currency in recent times as the complexities of disputes, cross-border transactions running into billions of dollars are at stake and come up for adjudication by such panels. It is believed that diversity amongst decision makers is necessary to improve the quality and rigor of the decisions which they render and enhance the legitimacy of the dispute resolution process in rendering fairer decisions. Adjudicatory systems with decision makers who are from diverse backgrounds, more inclusive, representative, are more likely to be perceived as legitimate in their decisions and more likely to be complied with, as they bring about a certain kind of democratization in the arbitral process. The underlying rule of a fair adjudication is that it must be impartial, there must be lack of bias. And I think that is very fundamental to an alternative dispute system if that has to be resorted to. Diversity is also a multifaceted concept. It would include gender, it would include regional representation, legal training, cultural diversity, and racial diversity. Gender diversity, apart from considerations of equality, many in the arbitration community believe that diversity on tribunals improves the quality of decision making as different perspectives lead to better decisions. This is backed by evidence in the financial performance of companies where gender diversity has been brought on board. Improving gender diversity will introduce fresh blood on arbitral tribunals, which is necessary to maintain a sustainable pool of arbitrators. In fact, the number of women arbitrators around the world is abysmally low, and I think positive effort has to be made to increase the pool with a large number of women who have taken to arbitration as an avocation and are available in various parts of the world. Apart from gender, regional diversity is equally important because people from certain parts of the globe may not be familiar with the problems which are faced by countries which are yet developing and in the developing world because they have their own peculiar problems. Therefore, familiarity with these issues is equally important. On the same page is legal training, cultural diversity, and finally racial diversity. Each of these issues are very important in constituting a fair and unbiased panel which will provide a just resolution of disputes between developing countries and foreign investors in investment treaty arbitrations and also in international commercial arbitrations. With these few introductory remarks, we will now dwell on each of the issues which would comprise of diversity, and I will request my co-panelists to address the audience on the same. Now, with respect to the necessity of diversity in modern day arbitrations, I will ask Mrs. Pallavi Shroff to lead the discussion.
Good morning, everyone. Thank you, IAF, for hosting this session and inviting me to be here. I think just as Malhotra has touched upon so many of the topics that comprise of diversity, and why we come to that later, I think the first question that we ask ourselves is, why do we need diversity? I think it's a pretty stupid question in many ways if I even asked myself this question, but yet we need to ask this because today we are faced with a situation where in the world of arbitration we find very few women arbitrators and very few women counsel as well. There are a handful of them who are known globally and who get the opportunities to either sit on the tribunals or even argue. I think the first thing is that since arbitration is something that is party driven by party autonomy. Parties appoint arbitrators. The concept, the reasons that go into appointing A or B or C as an arbitrator is not known unless we, of course, there are a number of surveys that have been taken, but it's also some sort of a, you're familiar with a set of people, you have heard their names, they're more and more, and so you go with those safe hands that, a safe bet, safe pair of hands that you want to see in your individual arbitrations. But that begs the question that you need different perspectives in any disputes that you need to resolve. So women, adding diversity, and I'm not going to restrict it myself only to diversity through gender, though it's one of the most important. So if you add a woman, does it change things? Probably different perspectives bring. The decision-making process will, of course, remain the same, because the woman would be as judicially trained or legally trained and would be able to contribute as much as any of the other members of the panel. I think it undermines, if you don't have enough diversity, in times to come, it is going to undermine the process, the integrity of the process itself. Today, we see that in society, almost 50% of society, 50% of nations is women. And yet, because maybe of our inherent biases, we don't see women in certain walks of life. Now we see so many women in the legal profession in India. Way back when I started 41 years ago, and when just as Malhotra started, we were probably 3 or 4 of us who started and who came to court every day, and we argued. So the perceptions have changed. This hall itself, the audience in this hall itself shows the number of women who are at the forefront of arbitration. I think they're waiting to get an opportunity so that they can bring their perspectives and their abilities to the table in the decision-making process. The quality of the decision-making process will certainly improve. It would also lead to breaking down barriers. Now, today when we see you have societies making a serious effort to change, particularly on gender bias. Corporates are making sincere effort. The listed companies, the securities regulator actually mandates companies to have a woman director on the board. And there are some companies who will have more than one woman director on the board. And being one of these women directors on the board, I can tell you the quality of discussion is very, very different. When I've observed and I've participated, and the quality of discussion is very, very different. So given all of these, I think it's very, very important to bring in diversity. I don't think there can be sort of two thoughts on that. The very fact that we are sitting here today, all of you participating and we are talking about it, just actually highlights the problem. And if I can give you one example, which I think all of you may have probably heard of, is when Jay-Z actually sued the American Arbitration Association. And why did he sue? Because in a dispute for breach of contract, when the institution suggested 12 different names of arbitrators, there was not a single black arbitrator that was nominated or even suggested for nomination. So that he sued the AAA to say he had a right. Now, whether his arguments were right or wrong is besides the question. Would he get justice if he didn't have a black arbitrator? I don't have a doubt that he would have got justice. But that very fact that he could sue the AAA, it highlights the very fact for the need for diversity even today. And more today than it was probably yesterday, because we are far more conscious of the need for diversity than ever before. I think different areas of diversity, but Vyapak, once you comment on this, I think we can then both of us can move on to the other aspects of diversity, which just as Malhotra just mentioned. And I think one of them is the racial or the geographic diversity. We have people from all of you sitting here, and some of our guests have been doing arbitration involving different countries, developed countries, developing countries, particularly BIT arbitrations, and you'll see a developing country, developed country, and you'll see an arbitration tribunal, and pardon my language if I use this, of 3 Western men sitting there. Where they have, sorry to use this again, but very little perception, very little knowledge how Brazil runs its government or how India runs its government, what are the priorities, what are the processes, you know, sitting somewhere in Europe or in the US, trying to decide whether the Indian government was right or wrong, you know, with no knowledge of how India runs its business. I think that's something that we need to break. Diversity, if you bring in the racial diversity, I think that brings so much more value, not only through the BIT arbitration, but even to commercial arbitrations. Indian companies face a sort of a bias when we go to you know, the international arbitration, when companies are saying, oh, we do business in a certain way, which is question mark. It's not the case. You think India is one country that always does business like that? Absolutely not. But if we had somebody who understood the region, who understood how businesses are done, I think that makes a huge difference. Then you look at age. Average age, 55, 56, sometimes even more. What about younger arbitrators? You have now the YAF, the Indian Arbitration Forum that's coming up, which is of young lawyers that aspire to do the work arbitration and become arbitrators in the future. Geographies, you have differently abled. How many tribunals even have a differently abled arbitrator? We know they have challenges, but do we create more challenges for them and more hurdles for them by not even considering them? You have religion. You know, there are so many different aspects of diversity which we should be thinking of when we look at appointment of tribunals.
Yeah, maybe a couple of minutes, but I think talking about diversity, it's not a new subject, right? It's there everywhere, right from our personal lives to any corporate life that we talk about. And it's always, in a broader sense, at least in my perspective, connected to decision making. That if you bring diversity in every aspect of decision making, the decision is generally better. There are a lot of scientific studies and statistics around it as well, but we don't need that to prove that issue, right? And where else decision making is the most important and critical part of the process, which is a dispute resolution system. And therefore, if we don't bring diversity in the decision making of a dispute, then we are basically, you know, not acknowledging the most important and the critical part of decision making, which is diversity. Again, this is something when I started practice not long ago in that sense, but we always heard about, you know, the coined words like mafia, which is Mutual Admiration Forum for International Arbitrations, who are appointed as arbitrators. People used to say male, pale, stale, and you know, we used to hear all of this all the time. But I think things have changed. Things have, you know, definitely come, if not full circle, but there are many initiatives, like even the pledge initiative is going on across the world, which is, you know, growing. And as Ms. Shroff was talking about, in fact, I talked about this a couple of years back at LIDW as well, that this is now the new race, age, gender, and ethnicity. I think this has to continue, this has to make some impact in our field of dispute resolution. And I may just take a little 2 minutes on IF as well, because one of the reason why we you know, thought about the concept of Indian Arbitration Forum was basically a three-pronged strategy. One was we wanted to make sure arbitration doesn't remain alternate dispute resolution, it becomes parallel dispute resolution system, because unless that mindset change, it's not going to you know, make a difference. Second, we also wanted to strengthen the ecosystem on the soft law. So we keep coming out with guidelines on running conduct of arbitration, online disputes, how to run virtual hearings. But the third and the most important part was to bring diversity as part of the ecosystem in the arbitration. Women lawyers, young lawyers, lawyers from different regions. We are spread across whole of India now. We have conveners and members across India to develop the arbitration bar. The whole idea was to bring in that as part of the forum, and maybe we'll talk about it as we go along on the session.
Just
So,
as Malhotra,
thank you.
may I just add one point? When you talk of geographical diversity, I just want to say, since I sit on as an alternate member to the ICC Court of Arbitration, in 2015, the former president of the ICC Court actually changed the face of the court, where he consciously brought in 50% of the members as women members. You see the level of participation, it's phenomenally high. The quality of the debate, very high. Women will come very, very well prepared, having read every award, and we get to read so many awards for even one meeting. And I can just give you some statistics on that. 13% of the members are from Africa, 26% from Asia, 39% from Europe, 4% I think from North America, 15% from Latin America, and 3% from Oceania. What a regional diversity. Though this may not be entirely reflected in the tribunals that get constituted, but this is as a result of a very, very conscious effort made by the ICC. Today we have a woman president at the ICC, Claudia Solomon.
Mr. Rajesh Pillai, would you like to speak on the impact of socio-economic factors on diversity?
Thank you, Madam Justice. I think that the context for considering the socio-economic factors that are relevant to diversity is essentially that we are trying to push away from the status quo, which Mrs. Shroff and Vyapak have explained. We want more participants from the states in which the users, the businesses ultimately, are based. And it's right, though, not to forget that we want to raise standards across the board in written and oral advocacy, in efficiency, lower costs, ethics and conduct, and ensuring that we have effective judgments, awards, that the parties feel fairly determine their disputes. Because if we don't have that, then you've got that legitimacy deficit. And there's one particular I wanted to give in relation to the point that has just been made about diversity. I mean, it's not just about presence. It's about the fact that what's called in some literature the outsider view causes the people who are already incumbents to actually then double check what their thinking is. So that's the whole point. It's almost as if it's a cross-check of a view which otherwise might not be contemplated, and a review which wouldn't otherwise take place. So one way in which I've seen it put is that diversity avoids disastrous decisions because groupthink is challenged. Now, as to the impact of socioeconomic factors, I think this is really about access. And Justice Malhotra, when she opened, talked about democratizing arbitration. And by that, I think, for me, that means removing barriers to access, and it means removing ideas of a mystique about arbitration. Now, I appreciate that that may not be a palatable view to those who work in big arbitration departments and so on and so forth. But really, we're all dispute resolution professionals, either arguing or having argued, then gone to the bench or to sit as arbitrators. And I've never understood why arbitration should be viewed as some sort of magic or some sort of difficult context. It's fighting your cases, applying different rules. There is some context for laws of seat and so on and so forth. But I think that if one creates a mystique, then that makes it appear harder, makes it seem harder to get into. And I think that's wrong. And it's the sort of thing that might hold back access. I think I recently saw a talk entitled The Art of Arbitration. Now, I appreciate that these things are just to catch the eye, but the more you sort of create an idea that this is some sort of particular set of skills that might be different from what you train as in your own jurisdictions, the less appropriate it is. Now, in relation to access, something for us all here to contemplate and perhaps look at how you yourselves got to wherever you have reached or whatever path you're aspiring to. I think that getting into arbitration does seem to me quite an elite pathway. Often you've got practitioners who've got an LLM level education, then go on to work in a large law firm arbitration department. I mean, traditionally, probably even when I was starting, you would have done some sort of Freshfields, Paris or London or equivalent. Now I think you expand that to Singapore and Dubai and Hong Kong. Then you get staffed on big cases, often mentored by one of the big name partners. Alternatively, through your firms nowadays, I think you can join the young arbitration groups. We've talked about the Young Arbitrators Forum, and each of the SEAC and LCIA and ICC have got fora for younger practitioners. Then you attend conferences, you can write articles and comment on articles. But all of this is not essentially something that one can just start off doing. I mean, I think that access to these, to get sponsored to go to conferences as a junior, even as a junior barrister, for us, you have to pay to go to any of these things. And that can be another expense to add to all of the other priorities one has in life. I don't think it's as easy to get to as it might be. Now, it may be now that, particularly with developments in remote access, that we can attend conferences more broadly and more readily. But again, from what I've seen in practice, for any high-level arbitration of any decent value, you've always still got the best-known firms. And there are narrow and highly competitive pathways to getting into those best-known firms. Now, of course, one view is that that's a meritocracy. So it means that the best get in, because the people with the best results and so on, who've proven their chops, are going to be doing this. Now, that would be okay if that were right. And I think we all have to scrutinize ourselves and our own experience to see whether it is a pure meritocracy. But I think it's important in terms of getting a democratized international arbitration practitioner forum and basis that we try and break down what may be barriers, particularly vis-a-vis the developing world and the sort of institutions of which we study.
Any comment?
No,
All right. So now we'll go on to the issue of regional diversity, which I think has really come into importance and it's become very current, is in the context of investment treaty arbitrations. There are awards which have been passed by arbitrators all from the global north, and it is with respect to a lot of developing countries where they feel that the awards are lopsided. They are not sensitive to the peculiar conditions in developing countries. In fact, in the white industries case in India, the primary ground for passing the award, one is that the panel was completely, it was one Britisher, one American, one German, nobody from the developing countries. The award was passed on the ground that it took too long for the Supreme Court to dispose of the matter, and they said judicial delay is a ground, and on that ground the award was passed against India. Now, they are not aware that it's a highly burdened judiciary which is catering to 1.3 billion people. Secondly, this was a matter which had got tagged at the request of the investor to a group of matters which were to be decided by a larger bench of the Supreme Court, and that is how the delay happened. So to pass an award on the ground of judicial delays without appreciating the local conditions would not be a just resolution of the dispute, and developing countries have reacted, and that is when it became as a wake-up call. India terminated its BITs with most countries for the reason that the format which was being followed was the 2003 Western model, and it protected the foreign investor even after termination for a period of 10 years during the sunset period. Now, a similar situation happened in Seychelles, where a whopping award was passed. It was a completely unequal fight on both sides, and in fact, the appellate body found that there were certain discrepancies, huge costs imposed which would have wiped out the economy of that country. Then Ecuador, South Africa all started reacting, and they said they brought in their Protection of Equal Rights Act, wherein they said, please go and exhaust local remedies before we start getting into investment treaty. They are extremely expensive. They go on for years together, which is very difficult for a developing country to withstand. and they cannot match the costs which are put in by a foreign investor. So in these panels, regional diversity, I think, is of crucial importance, that there is representation from the developing world, and so that there is a more just resolution of disputes. So that is one of the areas where regional diversity has been propagated, because it's an unequal fighting level. So it, on both sides. So, and if the panel is completely constituted of people from the developed world, then they feel that it's necessary that the dispute resolution process is seen to be just. If it's perceived to be unjust, then there is a legitimacy deficit which arises. Mr. Pillai, would you like to say something?
I think one counterpoint, I suppose, is that you have this BIT regime, or we had it, in order to provide certainty for investors who perhaps weren't that familiar with the investor conditions in other jurisdictions, India being one of them. And so a counterpoint would be that without some sort of protection in the form of a contract and dispute resolution provisions that the state had signed up to, there wouldn't necessarily be the conditions and stability for safe investment and ability for redress if you didn't have that protection. And I also think a related point is, you know, when you come to arbitrations and requirements for things like disclosure, it is a feature of a number of common law jurisdictions, as perhaps distinct from certain civil law jurisdictions, that parties will expect to have disclosure of systems and how they operate, and internal government systems. So while there might be discomfort on the part of particularly states in having to, as it were, wash their dirty linen, that also can be, it would be a function of open justice and a fair fight if you can see the material and what might be otherwise held back. So I think there's always that important counterpart. And I say this, obviously being trained in England, where we have pretty strong disclosure obligations, even under the sort of new, narrower civil disclosure rules. My experience is that arbitrators do tend to be a little bit coy about ordering disclosure with the sort of red phone schedules and IBA rules. But I appreciate, Justice Malhotra, that there is a different perception about having to show these documents and things in a different place.
So Rajesh, if I can come in on that and comment. I think one is the hesitation of state governments or the sovereign governments to make such disclosures, because does it impinge on their sovereignty itself? And I think no country wants to give up its sovereignty to 3 people in an arbitration tribunal, even with all the diversity that we talk about. So I think it impinges on the sovereignty, or that's the feeling. I think that's the first aspect. Second aspect is, even if you were to disclose some of these documents, how they will be interpreted and how they will be read, without understanding the true functioning of the government or the practices of the government and how governments operate. And they operate very different in the Western world from a developing world or a country like India. I mean, I can speak about India, and I think it's poles apart. So to impose or view these documents from a perspective of what the tribunal is familiar with in the Western world, and to expect that should be the standard in India, I think that's where I think is a problem, you know, apart from the first of sort of impinging on the sovereignty.
And look, I should say, and I was on the Attorney General's panel for a decade, and the UK government is not that keen on disclosing documents. I mean, there's just been a decision, I think, this week about MI5 and its failure to, you know, even in domestic litigation, because people are suing government departments all the time, there's not a sort of approach that that is positive towards document disclosure. And even in relation to Freedom of Information Act requests, I think recently HMRC in London, which is the tax department, they had to cough up an email which said our approach to all of this should be not to disclose if we can avoid it, which is not a surprise. So, I mean, it's an instinct.
At least from a context, we can talk about the commercial arbitration separately and the stakeholders. But I think from a treaty arbitrations, right, I think there is, very easy discussions over the table happening. Okay, these arbitrators are state-oriented, these arbitrators are investor-oriented, these are developing countries, these are non-developing. It was becoming too obvious. But actually this raises a very serious question. Who appoints these arbitrators, right? At the end of the day, broadly parties appoint to start with, or the institutions, and then where do we go with party autonomy and the appointment of arbitrators, right? So I think this goes pretty much into the very basic structure of arbitration per se, because that is raising doubt to the investment treaties itself. While you are just talking about dispute resolution and how to make it more at least perceptionally better or no bias and giving access to justice. But in the context, what has happened is, while, just to give an example from an India perspective, while we signed almost 75 treaties between 93 and 2007, I guess, and then first white industries and then few more cases, and now we are left with only 4 or 5 in the new regime, right? Only 3 or 4 were signed in last 3 years, and some of them are already in their sunset clauses or not extended. So I think one single element of dispute resolution is taking away many other aspects of BIT. So you can see the impact, and this is not only India related issue. This is happening worldwide. There is a moment of going back to the courts or having a different system of appointing judges or arbitrators, so to say, to at least start your process. And where does party autonomy go in the appointment of arbitrators? So I think while we discuss about the stakeholders as we go along, but in my view, this is going to the very basic structure or the basis on which the arbitration stands today. If we don't get it right, then there will be a huge debate on party autonomy versus appointments, and which is going to go in a very different direction, because this will challenge the very availability of an dispute resolution system which is based on party autonomy. So.
Just as a sequel to what Mr. Vyapak Desai said, even though party autonomy is that both parties nominate one arbitrator, the presiding arbitrator then really, wherever he tells is the award which is passed, and most of these awards are divided. They are 2:1, and the perception therefore is that if you get an arbitrator who is pro-state as the presiding person, then it may be a fair resolution for the state. If it's pro-investor, it's going to be a loaded award. So that perception has to be dispelled. There has to be a more balanced panel to adjudicate on these disputes, rather than it being loaded and a person feeling, one of the parties feeling it's a foregone conclusion. That perception has to be removed. And insofar as Mrs. Pallavi Shroff just mentioned, I would agree with her. In a recent investment treaty arbitration, the state was compelled to produce certain internal documents, and they said you cannot get this in a domestic arbitration because under the Right to Information Act it's not permissible. But you see, these panels who are unaware, they insist that these documents are provided. Some of them are confidential. They are exchanges between the Prime Minister and the minister concerned. So, but they are compelled in these closed door proceedings, which is something which is problematic. And that is why probably the reluctance to produce these documents rather than really a coyness, there is a reason behind it. Mr. Desai, can you tell us about who are the participant stakeholders and what are the steps they've taken? Are they enough with respect to diversity, or what would be your suggestions?
Yeah, I think we just touched upon the biggest stakeholder, the parties, right? I think, I don't know what can parties do unless they have the right information and access, because they are the biggest appointees. We can go into statistics of what institutions are doing. I think, Ms. Shroff, did mention about what ICC is doing, and we can move percentages here and there, 27% more than last year, which may be 2 to 3 or something like that. But I think this topic possibly doesn't require too much of statistical discussions, but it requires more of emotion and empathy kind of a discussion, right? Because this has an element which statistics are not going to help. Of course, from a stakeholder's perspective, you have parties who appoint the arbitrators. There are institutions who have the second right if parties don't appoint, or parties have already decided that the institutions would appoint the arbitrators in case of a dispute. And in Indian context, a large part of appointment still happens through courts. So if you really see what happens worldwide, maybe it is party appointed and institution appointed. But if I see from an Indian perspective, I think majority of the appointments, particularly when there is a dispute and parties don't either nominate their names of arbitrators, or they have a dispute on a sole or the second arbitrator or the third one, it is usually the courts, either the high courts or Supreme Court, as the case may be. So in my view, from an Indian context, at least till the time the new amendments are in place, the Section 11 amendments which are still not applicable, where institutions would be possibly granted the power or the authority to appoint, I think courts is going to make the biggest difference. So if we can start the process there, where diversity is adopted by the appointing authorities, particularly under Section 11, I think that can make, in my view, a sea change, or it can be a game changer in my perspective, because that's where the problems of only looking at people who are in front of you versus looking around is happening. So in my view, these are the three elements which requires a clear education, or at least a clear change in their outlook when it comes to appointment of arbitrators.
Mr. Pillai, your comments?
I don't have anything to add on that.
Mrs.
So let me look at, take a step back and look at who are the stakeholders and what role do they play, each one of them. I think Vyapak started with the parties. While I don't think it's a statistics analysis or anything, but I think it's important to know, I just have some 2018 data. In ICC, 57% of the appointments that happened were party-appointed arbitrators. In LCIA, there was about 46% of the arbitrators were appointed by the parties. Since the parties are the largest player or the largest stakeholders who appoint arbitrators, I think how you approach change in the mindset of the parties themselves. Now, we don't know what sort of considerations go. One thing that I'd mentioned was, I want to be in a safe pair of hands. I know what the thought process is. Maybe I don't know enough about the woman on the, or from somebody, some other country. So how do we improve the ability of the parties themselves to make these decisions on gender, diversity, age, race, geography, all of that. So some data being available on the performance of each of these global people who sit on these arbitrations, I think that could be important, because this itself is a game-changing. The more parties appoint, the better it gets. Parties are typically supported by their in-house counsel. So when in-house counsel now, and I have seen this not only globally, but even in India, number of them have literally like what they call targets on diversity. Some of the Western clients will ask us, even before considering a law firm, what is your diversity program? What is your inclusion program? And unless we satisfy them on that, they won't even move forward. So you may be the best, but they will not appoint you. So similar concepts are coming in, a bit slower, but yes. So I think the in-house counsels play a huge role in suggesting to their managements that having a woman on the board or having regional diversity, geographical diversity makes a huge difference. Very, very influential general counsel. I think the third people could be the law firms. you know, these large law firms with huge arbitration departments. Yes, and I am proud to say that in my department, I have at least 5 women partners who focus only on arbitration. You know, we need to encourage them. We need to first draft more and more people into our arbitration practices. They are the future arbitrators. They have to be groomed and trained to become arbitrators. So I think, and then giving them the opportunity to either sit as arbitrators or lead arbitrations, I think that's the next set of, you know, and equally, if I know women in other jurisdictions, am I willing to suggest the name of somebody in maybe Sri Lanka or somewhere else in Brazil? You know, I think that makes a huge difference. The third, I think, are the co-arbitrators themselves. When you appoint the chair, the presiding arbitrator, how many of the co-arbitrators actually think that, you know, as a first thought, let's have regional diversity, let's have gender diversity? I've seen that in India, when we appoint retired judges, one will have somebody who's retired 2 years ago, the second person will be retired 3 years ago because he's a little senior, and the two of them will appoint somebody who's retired 8 years ago. So the age keeps increasing. Is that the criteria that we are going to appoint? Why not maybe a senior counsel who's much younger, but very competent? Why not that? You know, so I think those are mindsets that we will need to change. Why not a woman presiding arbitrator? You know, so these are other important institutions. I think, Vyapak, you've already mentioned. Institutions, of course, play a huge role, but they will need to have it as their priority. And I think the various conversations that happened across the globe, the pledge that has been, you know, signed by so many of us, I think all those are steps that are being taken. But is it now time for that pledge, which is a sort of a motherhood statement, to come down to softer targets that institutions want to sort of impose on themselves? Because all this has to be self-imposed, you know, and to feel the pressure of other institutions doing something versus this institution not doing something. I think that is what is critically important. I sit on the Mumbai International Arbitration Council Governing Board with Vyapak, and I've realized, I think even you are there, ma'am. So we realized that so many young people are now being appointed. They always have the guidance of the secretariat and any of the members who appoint them. But I think that's like a first beginning. And I think these are the kind of steps that we actually need to take to encourage diversity, you know, in the
fact,
arbitration. There was a comment made by Mr. Vyapak Desai that why don't courts exercise their power under Section 11, but I must tell him with some pride that in the Section 11 jurisdiction, the Delhi High Court has appointed a very large number of young lawyers as sole arbitrators and who've done an exceedingly good job.
Sure.
So the courts have certainly are keeping in mind that if there is a competent lawyer with 8 to 10 years practice, they have been appointing them and they have been discharging their work really well.
Sure. See, I think diversity is all about inherent bias in my view. So one experiment maybe all of us can do is whenever we are selecting the arbitrator, we can even have blind CVs, right? It's only about qualifications and experience and then see what comes out in the decision making rather than we have the name, the gender, where they come from, Delhi, Bombay, High Court judge, Supreme Court judge, it can be any, right? But if we just put qualifications and experience and the rest is all blinded as an experiment and see what you select and then you suddenly pop up the rest of the CV profile related issues and then you decide what you select. I think it can be a great experiment even as a workshop while you can put 2-3 people on the scene and say, okay, these are the 5 CVs, who would you select? And then maybe there can be a separate exercise with the profile and then you would see who you select. I think that can itself show a lot of inherent bias which comes in, which possibly are not intended, but it just comes in because of the baggage that we all have for many years now.
I actually have serious reservations about appointments being made on the basis of blind CVs. I think it's extremely important to know who the person is, his integrity, you know, his competence, etc. I would never go by a blind CV. I think it's it's too experimental, and I don't think I would be happy with it, comfortable with it.
I think it's just a starting point. You obviously don't make the final decision, but at least that will give us a clear idea on where people take.
I think I agree with Mr. Malhotra. Even if it were an experiment, I tell you, when we select arbitrators, even if it's a retired judge, let's start with having a retired judge. We want to know who the judge is. We see what are the views that the judge has taken. You know, and we know some views are going to be against a party. The party will never appoint. It's reality. But we know the arbitrator is neutral but fair. I think that is very important. Critical. The fairness of the arbitral tribunal is so important. And I think they may be actually fair, but the perception that
is very important.
Is even more important.
Sure.
In fact, in various international arbitrations where names are considered for appointment, I find that they do a lot of due diligence about the person. If it's a retired judge, they go through their judgments to see what is their perception, if they've been making public speeches. So a lot of due diligence. I don't think I would subscribe to the view of a blind CV.
In some clients, we even want to sort of talk to the potential arbitrator.
Yeah.
At least just get the gut feel of, you know,
what he or she is thinking.
He or she is, what the views have been, discuss something. And this is becoming more and more common where we are asked, can you give us the CV of the proposed arbitrator? Of course, some of our retired judges don't like it. But that's the world today.
Mr. Pillai, will you address on the aspect of how to improve diversity and any recommendations you would make?
I think I can be quite brief because there'll be no doubt be questions. I can be less than 10 minutes, I promise. I'll talk firstly about steps taken so far, and obviously the fact that we're all here today and there's been well over decades of academic writings and articles means that it's all about bringing this to your attention and then having thinking about diversity in its various facets when you're making appointments and so on and so forth. So we've got awareness raising. We've also touched, as various panel members have talked about, on the fact that this is already part of a wider discussion that's going on often within our clients themselves and their boardrooms in order to improve decision making. There are lots of initiatives that abound. Some examples, we've touched on the pledge. That's the Equal Representation in Arbitration pledge about gender equality. There's also, I think, early this year, equal representation for expert witnesses, because you may or may not have noticed, but often our expert witnesses in disputes are also often men. There is the regular ICA reporting on gender diversity. Again, that's about gender diversity. I have here my prop, which is their November 2022 update, which has got a lot of statistics in it, which I'm not going to bore you with, but it's all online. There's something called the African Promise about increasing representation from African states. There's a nuance which I was alerted to last week, the Scottish Arbitration Centre, which is a new venture in Edinburgh, sort of set up and coming more to prominence after the ICA conference in Edinburgh. It has a change in its arbitration rules at Article 8, which says that in proposing or appointing arbitrators, parties and their counsel, and also the centre itself, should have regard to the ERA pledge and also to the Racial Equality for Arbitration Lawyers initiatives. And it goes further to say that any previous agreement on gender, race or ethnicity of the chosen arbitrator shall be of no effect, but that obviously any other requirements as to qualifications will be enforced. Now, I think that's an interesting approach, and it takes me to the next steps aspect of what I'm to speak about. There are two areas, and really what Mrs. Shroff was talking about covers it. The first is that parties and their counsel need to look at what they need and prize in their appointees and cast the net accordingly. The second is that co-arbitrators also need to consider these matters. But then the third is about institutional rules. And obviously I've cited what the Scottish Arbitration Centre has done, query how that would really be adopted into the more established arbitration centre rules, the ICC, LCIA, and so on. But there was an article by two lawyers at Vinson & Elkins, which is a big US firm, in an open letter from November 22, suggesting this language. So they say, well, look, institutions need to do their part as well. We've talked about the private side of it, but the institutions perhaps could use this phrase, that where parties are appointing and where the institution itself is appointing, that they should strive to appoint a diverse tribunal, to use language of that sort. Now, that obviously, to me, sounds like a best efforts or a reasonable endeavours clause in a contract. And the point of it is twofold. First is to make you think about it if you haven't thought about it already. But the second probably is that it requires an effort to be made. You might have to paper it, so that you can say, well, what did we do? We put our minds to it. This is what we thought about. This was the conclusion we came to. All of this is a soft, because you can't force diversity upon parties. You can't force diversity upon the stakeholders. It all needs to be effectively a ground-up impulse. And so those may be ways forward.
Thank you. We'll open the house for any questions. Yes. You want a mic? Madam, can you give her a mic?
Yes, sure. We have runners across the hall. Can you please?
Hello, I'm Leanne Mulcahy. I'm a KC from London, Fountain Court Chambers. I just wanted to pick up on what the panel had been discussing on diversity and just support it really from my own personal experience. I've really benefited from the institutional push for gender diversity and have been very grateful to the LCIA in particular, who appointed me as initially as a co-arbitrator and then as a sole arbitrator, which enabled me to get started. My experience at the time was it was very much more difficult, if not impossible, to get party appointments as an arbitrator. And indeed, I was appointed by two very seasoned co-arbitrators as a chair in an arbitration, and the parties then refused to allow me to be appointed. Now, this was notwithstanding I appeared as arbitration counsel and also had sat for a number of years as a deputy part-time High Court judge, including in the commercial court. And they cited lack of experience in arbitration. And I'm conscious it's quite chicken and egg, because how do you get experience and enabling you to be appointed unless people are prepared to appoint you? And I see a similar argument in relation to specialized areas of arbitration like maritime and commodities, where there is fierce defense of being able to have small pools because of the need for experience and expertise. And repeat appointments are permitted, and you end up with the same people being appointed over and over again. And it becomes very hard to break into, even if you practice in that area. So what I wanted to ask the panel was, how do we avoid experience, which is clearly desirable, but is often treated as an absolute requirement, becoming a barrier to gender diversity, age diversity in particular, and also ethnic diversity?
Thank you.
You want to start? No, I think it's to start with, obviously everybody wants to choose someone they feel is experienced enough to deal with your dispute, right? You have that right or party autonomy to choose an arbitrator, therefore you want to do that. So in my view, it's not unfair for a party to feel or decide that, okay, I will go with someone who has some experience in a particular area, particularly, as you said, for specialized arbitrations in maritime or shipping or construction and those fields, because then they tend to make less mistakes, or at least it is perceived that they would, make less mistakes. I think when it comes to diversity, particularly on the experience side, I think that's where, in my view, parties are always going to go with some of the advice, as Mr. Shroff was talking about, that they get from in-house counsels, they get from the lawyers that they appoint. But more importantly, at least I have seen in the past, and maybe it's your experience as you rightly said, it's the institutions who take that leap of faith. And I think while in global stage it is institutions, and as rightly pointed out by Justice Malhotra, in India it is the courts who take that leap of faith to say, I know in spite of a person being young, but potentially has a very good experience, or at least can deal with a situation of such a nature. And if you see the world today, right, the entrepreneurs or the way the business is run, I think 20-somethings are possibly running the world in most of the business things, right? They are no longer CEOs with 50s and 60s and 70s. So I think if you can draw some parallels and take those leap of faith, that okay, 20-something can run a 10,000 people business or $1 billion business, then why not an arbitrator with a younger nature? And the other thing which I always talk about, that when it comes to judiciary and appointment of district judges or civil judges, they are all 20-something judges, right? And some of the jurisdictions that they have is pretty high jurisdiction or complex issues. If a 27-year-old judge or 28-year-old judge or 32-year-old judge can decide a very high stake, not maybe value, maybe from different perspective, or a complex criminal trial or a complex civil issue, then why not an arbitrator who has to remain in the four corners of basically the contract. They don't have to worry about discretion of the court, they don't have to worry about constitution and nothing else, right? So frankly speaking, I think it is purely a perception on experience. Otherwise, in my view, there is no difference between a young judge versus a young arbitrator. And frankly, I was the beneficiary of getting appointed very young as well. But I don't think a lot of people get that advantage, and it changes the whole perspective. So I think it just requires that leap of faith. Yes, ma'am.
Yes, yes.
With the leave of Justice Malhotra, I would really agree with what Mr. Vyapak Desai has just said. When we appoint judges, either to the district judiciary or to the High Court, we do not ask for expertise in every subject, because a judge has to deal with all subjects. So even with one little experience, if you do well in practice, even in a couple of subjects, you are elevated as a judge. So I think as we move from ad hoc appointments to institutional appointments, the only way to take it forward is to apply the same standard which is applied for judges' appointments to even arbitrators. Somebody who may not know copyright law, I'm sure if he's done commercial law, can do a copyright dispute. So it's all at the end of the day, it's about fairness, equity, and justice. So if these three things can be watched, I don't think anything else is needed.
Thank you.
Ma'am, can I add to what Justice Pratibha Singh has said? I think first, thank you for sharing your experience. I think it's hugely important for all of us to know that these are the problems that women who get appointments have, not only first in getting appointed and then getting questioned as to their experience. Experience is always relative, and I think as Justice Pratibha Singh just mentioned, you have the experience of adjudication. It's whether you're adjudicating a shareholder dispute or a commercial contract or something else, that can vary and will vary in an arbitration. You know, none of us do the same thing every morning. So if you've had the experience of adjudication, the process of adjudication and adjudication itself, I think that's huge experience, and that's what counts. And ultimately, if the you've been appointed by the institution, it is for the institution to back you in any challenge that is made to the institution in throwing it out. You know, these things do happen, but if the institution supports you, I think parties realize that maybe they're stuck with you in that sense, but they have you and they have to deal with it.
Thank you. Justice Malhotra, we have a question from
Yes.
the back.
Yes.
Hello, ma'am. First of all, good afternoon, and thank you so much for such a beautiful session. It was really insightful. While Pallavi, ma'am, clearly mentioned about the stats across the institute, and Vyapak sir said that we can reformulate the soft guidelines and can make it more inclusive. While we all are talking about the inclusivity through pledge and reformulation of soft laws, I want to pick your brains on what is your idea about the domestic law. For example, if I talk about the Islamic laws, it does not allow women to be a judge or an arbitrator. Saudi Arabia did not even see the first appointment up until 2017. Like, I met this women arbitrator in Europe who had to recuse from a case because one of the party was Arab and they refused to do the arbitration if she was sitting as a panel of arbitrator. So how do you think, how can we go about the domestic laws at the same time? Because there is a big challenge. A lot of business comes from these Islamic states. So how do we curb that issue? Thank you.
Well,
Complex.
it's a complicated issue. I mean, I'm not sure, I can't speak for Indian law, so I'm going to pass that on. But I mean, otherwise, I think that where an arbitration agreement provides either for institutional or ad hoc, if there's no agreement that there should be a particular type of arbitrator appointed, then I don't think that those sorts of challenges would be legitimate, in my view.
Yeah, that's true.
In India, we don't have any bar at all with respect to religion or any kind of bar from anyone being appointed as an arbitrator.
I think
we tried to bring in through our Schedule 8 at some point in time, not a very hard law in terms of qualifications of arbitrator or some set of rules around the appointment, but that also didn't work out because everyone understood that this is not the genesis of appointment of arbitrator. While we want to have right people, but you cannot prescribe it in any form, because this is a very, very dynamic issue, and you cannot prescribe it in any form or a letter that, okay, this can be your arbitrator or this cannot be your arbitrator. So in my view, it would never sustain the scrutiny of law as it goes further.
I think if you were so particular, somebody was so particular that they did not want a woman arbitrator, they would have said in the contract or in the arbitration clause that it's governed by Sharia law. And if it was governed by Sharia law, then automatically you wouldn't appoint a woman as an arbitrator, correct? So if it's not defined that this is governed by Sharia law, there's nothing that stops them. The only community that I have come across in India, because I've experienced this myself, is the Swaminarayan sect. They have disputes because they have huge tracts of land across the country. They will not deal with a woman lawyer. So I was dealing with their cases and they said, sorry, but you cannot be our lawyer. And they had to go to a gentleman to be their lawyer.
But in so far,
this is the only community that I've come across who will not sit across the table with
but
a woman
in
lawyer.
so far as India is concerned, there's never been any embargo on a woman being appointed either as a judge or as an arbitrator. The 8th schedule was also introduced in part 1 of the Act with respect to domestic arbitrations, and that was they wanted to improve the level of competence of a person being appointed. So they said you must be familiar with the local laws. In any case, the 8th schedule has been deleted. So, but there was nothing discriminatory. They just said you must have a basic knowledge of Indian laws. That was basically it.
Yeah.
Thank you.
Yes.
I believe there are tons on the floor. We have time for 2 more questions. So I would request the lady there and then the gentleman in front.
I'm a lawyer. It's more of an ask rather than ask a question. So we've discussed, that there should be, there should be inclusion of women, whether by pledges or even that CV example that you gave. Which triggered a thought, so just bear with me for a minute. So for instance, there was a company which decided to try and induct people using this blind CV method and using AI. And even the AI had inherent bias because there were so many men whose CVs were examined as opposed to women. The AI ended up believing that men are generally more bound to be successful than women, right? So when we're having this discussion, we're talking about women who've already become lawyers and therefore should, go ahead and be groomed as arbitrator, which is something which Pallavi ma'am touched upon. But I think something that needs to be looked at also is the level of when people are in law school or perhaps even schools, because how will you get women lawyers if women are not encouraged to get there, right? And even when, let's say, if I were to be in a stage where I would be interning, that is also the kind of exposure and nurturing that needs to be given. And I feel that is a conversation which is not out there enough, because what I'm asking 10 years from now is not a leap of faith that, you know, somebody to fulfill their diversity goal should appoint me. I want to have the opportunity to be recognized as competent in spite of my gender, not despite of it. So it's an ask in the sense if you could have a conversation at a later date in a different forum, or if there are some things that, you could maybe comment upon as a panel. But I think this is something that needs to be looked at.
So let me, Asta, let me tell you one thing. When we start with the colleges, the law schools in particular, there's almost an equality between men and women at the admission level and even till graduation. When firms, and all of us here from different firms here, when people are hired, I don't think distinctions are made between hiring men and women. And I think most of the times we end up having more women. Women have difficulties or challenges. I don't even put it as difficulties. I put it as challenges when they get married or when they have children. But that is the time when the institution where you work has to recognize this. These are normal things of life, and facilitate and create an enabling atmosphere, giving you flexi time to do work so that work doesn't suffer, but you have the ability to work from home or do other work. Secondly, today everything is electronic. You are connected all 24/7. Secondly, now it's mandated where there are more than 50 women, you need a daycare center. We had a daycare center 12, 15 years ago when this was not even the law, to enabling people who, after maternity leave, to come back and start working, bring the child to work. So there are different things that you can create for the woman, which enables. You have very strict posh laws, for example, not only the law, but how you interpret and deal with the fact situation on the ground to create that safety feeling. So everybody is doing this, at least from speaking on behalf of all the firms, I can tell you all of them are doing enough to recognize, the challenges that women face, and how do we enable that to happen.
Thank you, Pallavi.
Thank you.
Anyone else?
There's
question.
one question on the right side, which I will take from this young gentleman. He's been
Yes.
asking
Can you
for
hear me?
a while.
Hi, morning. I'm Saridishwar. Ma'am, my question to you is, when we look at increasing diversity and the role of stakeholders, let's say in emergency arbitrations, institutions such as the SIAC have the power to appoint the sole arbitrator in, let's say, an expedited process, looking at various factors, the nature of the dispute, the amounts. Can then institutions like the SIAC take steps to see whether the panel of arbitrators is not diverse, and then hold that maybe a certain different kind of arbitrator should be appointed to better adjudicate upon the dispute? So looking at the aspect of diversity and party autonomy and how they have an interplay with each other.
Sorry, but arbitral panels, say SIAC has an arbitral panel which is diverse.
Yeah.
It's regional diversity and gender diversity and age diversity. So, and they appoint who will be best suited for the kind of dispute when the request is made. So, I don't know, maybe I'm missing something here. We have Tejas here, who is a member of the SIAC board, and I think he can probably throw some light.
Why don't you answer? Tejas, you can take the mic and answer. Because I think most institutions have certainly incorporated rules.
Yeah.
Having
In fact, my first appointment was SIC several years ago, and nothing to do with India. So I think most of the institutions have lived up to some of those opportunities and expectations on them, and it only can get better. So I don't know.
Yeah, I completely agree, and the whole idea is to also not limit it to genders, but also get beyond gender and see that you have a complete inclusiveness. And if we talk about the panel, some institutions, they do not have panel, they have regional committees like ICC, LCIA, but they've ensured that there is a proper diversity in all respects. So as a part of the institutions, we all are involved in many institutions and see that there is a conscious effort to increase the diversity.
In fact, Ms. Shroff also mentioned MCI, at least from an India perspective, and we know a lot of people sitting here, a very young and diverse group of young and women lawyers and from different states, from different places, have already been appointed in India through those institutional
And
appointments.
all the heads of those institutions are also women. If you
Yeah,
see.
that's true actually.
Yes. ICC, SIAC, MCI.
That's true.
Thank you, Justice Malhotra. We'd like to conclude
Thank
the session
you.
with your permission.
Thank you, thank you.
Thank you
and
so
thank you
much.
to
everyone.
panelists, the audience. I hope you all had an interesting session.
Thank you so much for the panelists. One more round of applause, please. This was a very interactive session, and I'm so glad that it followed our inaugural session, making the plenary hall sessions definitely better than the auditorium. So I'm very happy. May we all please proceed for lunch. It is going to be hosted